existing armed attack. So did this happen in this case? Where there an objectively existing armed attack?
Yeah, Your Excellency, it is stated that in this in the oil platform case, uh, the reason that United States acting on this event is that they thought that the oil platform was a reason was a place for Iraq to create weapons of mass destruction, Your Excellency. But however, in the next report, it stated that it is not. It is actually not a place for creating weapons of mass destruction. So and then and then the relation of this with this current case is that Azura's attack uh, Azura's attacks were in line since the object of the attack was clearly weapons of mass destruction, and therefore the military goal was achieved, Your Excellency.
Okay, proceed. Thank you.
And entering our second sub-argument, Roxana possession of the nuclear missile is not in line with international law. This obligation is breached under customary international law, since in the Non-Proliferation Treaty Article 6, this state obligation applicable since first, the obligation was a result from a widespread state practices. Many of the states, irrespective of their subscription to the Non-Proliferation Treaty, they still taking active steps to reduce the number of weapons of mass destruction. For example, in South Africa, before signing to NPT, they ended their nuclear weapon program to negotiate its way to nuclear disarmament. The same occurrence happened into Ukraine, when once they possess the world's third largest nuclear weapon, but at the end they ended up entering a bilateral treaty that achieved the same objectives. Secondly, nuclear proliferation is also applied under opinio juris. From past resolution for recalling on all states, United Nations General Assembly
Agent, what is the definition of opinio juris?
Opinio juris is a law that is obligated to every state, Your Excellency.
And why is it relevant in this case? I mean, what authority does it have in front of this court?
It is to because under in the military paramilitary case in and against Nicaragua, it is stated that a customary international law should have two thresholds, Your Excellency, which is there are state practices and it has to be opinio juris, Your Excellency.
Right. So has there been state practice for that in this case, accompanied by opinio juris?
Yes, Your Excellency.
Okay. Can you name some of the states which practice that?
Okay, Your Excellency. For example, in United Nations General Assembly, it is stated that at the time it is calling to all states in which obligated to negotiate nuclear disarmament in good faith, Your Excellency, and in UNSC 3807 in 2003, it was a resolution that gives warning to North Korea to stop developing and testing their nuclear missile, Your Excellency, and it is counted as a customary international law.
Okay, proceed.
Thank you so much, Your Excellency. In the Tadic case, it is mentioned that UNSC resolutions are of a great relevance when evaluating the formation of opinio juris, Your Excellency. The Council has also affirmed the need of all states to conduct negotiation in good faith. Even though these resolutions were not binding, this court has recognized normative value in certain circumstances. And also in Article 25 of the United Nations Charter, it is stated that every member of the United Nations, every United Nations members should apply and listen to a national to a resolution that from the UNSC, Your Excellency. Thus, these contributions to Acuna Juris supported the state practices stated before, and it showed the existence of customary international law in correlation to Article 6 of the NPT. Hereby, Roxana's possession of weapons of mass destruction is a violation since it is not conducted in good faith, and it is a violation to customary international law. And it is not, and the possession makes it unachievable for a nuclear disarmament. Entering our second major argument, Azura does not have to pay for compensation for two reasons, Your Excellency. First, Azura did not do an internationally wrongful act, and secondly, Azura did not do an internationally wrongful act, Your Excellency. Entering to our sub-argument, it is Azura's only goal from launching their military force towards Roxana is based on good faith for disarming nuclear weapons, Your Excellency. They are in the possession of Roxana, and it is a threat to national and the regional security. In Article 36 of RCWA, it stated that state responsible for an internationally wrongful act, and it is under an obligation to compensate for the damage caused. In the Corfu Channel case, obligation to compensate arose from breach of international obligation by states. However, in the present case, it is submitted that Azura attacks was in line with international law, and hereby it is not a violation to it is not an international wrongful act, and hereby the attacks hereby as the Republic of Azura does not have to pay for compensation, Your Excellency. If this court has no more inquiries, may it please the court. Thank you so much.
Your Excellency, am I audible?
Yes, you are. Please proceed.
Thank you so much. Good afternoon, Madam President, Your Excellency. My name is Nazal Ami Firdaus, and I'm the co-agent appearing on behalf of Republic of Azura as the applicants in the current proceeding. As introduced by the first agents, I will be dealing with the last submissions in the next 17 minutes. I have the honor to address the applicant final submissions concerning United Provinces of Roxana violated international law in targeting Octagon with its hypersonic nuclear missile and must pay reparations to the Republic of Azura for the damage suffered. If this court has no preliminary inquiries, we would like to continue with applicant submissions. Madam President, Your Excellency, may it please the court. On 29 October 2022, the United Provinces of Roxana found that the constant dispute with the Republic of Azura would put them on the brink of collapse. Thus, they deployed their nuclear missile with the concern to raise the grave consequences for the Republic of Azura. This attack caused the severe casualties, destroyed the critical facilities, threat, and give constant trauma to the civilians. As it results of the attack, applicant raised claims against Roxana, namely, first, the United Provinces of Roxana violated international law in targeting Octagon with its hypersonic nuclear missile. Second, Roxana entitled by reparation measure for the injury occurred. Your Excellency, moving to the first claim that the United Provinces of Roxana violated the international law in targeting Octagon with its supersonic nuclear missile. As the concerns to raise the grave consequences for Republic of Azura as the applicants, we raised the lawsuits against Roxana under several reasons. First, respondent violated the charter. Second, respondent violated the international humanitarian law. And the last, Roxana violated human rights law. Moving to the first sub-argumentations. Why? Then Roxana violated the charter itself. There are two analyses upon these sub-argumentations. First, it's violate the principle of non-use of force. Under the Article 2, Paragraph 4 of the Charter, the state must refrain themselves to using force against other state territorial integrity. To determine the justifications for the use of force, through to determine the justifications for the use of force, we would like to bring the case of Nicaragua. The judge exercised that the use of force as a part of self-defense must be A, proportional, second, necessary, and to reason or to threshold. Referring to this proceeding, Roxana has no proportionality in using its force for attacking Azura, specifically in hypersonic nuclear missile. Proven by the causality effect by the attack was severely excessive. In addition, the attack is not necessary because the launch of nuclear weapon conducted by Roxana is not the only way to resolve the dispute or last resort. Thus, the principle of non-use of force was violated by Roxana. Second reason, Roxana's actions cannot be justified as a self-defense. The use of force is a part of sort in self-defense, which is acknowledged under the charter. However, this is subject to the principle proportionality and necessary. In the present case, Roxana's attack does not fulfill those principles. That is because Roxana unable interrogating the attack concrete and direct for resulting in military advantage. Also, it is not necessary because Roxana's attack was not an immediate response to the ongoing strike, and there is another realistic measure in achieving cessations of the attack. In sum up, Roxana's action should be not just in argumentations. Roxana violated international humanitarian law by using its hypersonic nuclear missile in targeting Octagon. There are three analyses for these sub-argumentations. That is because Octagon is not a military objective. Second, the hypersonic nuclear missile is an indiscriminate weapon which leads to the indiscriminate attack. The last, respondent violated its responsibility to maintain peace and order. Here are the analysis on those claims. First, Octagon is not military objective. Under IHL, an object must fulfill two elements to be determined as the military objective. The first one, it must have effective contributions. Second, it gives military advantage. In the present case, the attack targeting Octagon does not give a military advantage, where the military advantage should be concrete and definitive to the military objective itself. It is not unnecessary since the causality of the attack are not concretely addressed to the Octagon. In addition, in NATO bombing case, it is considered that the need to avoid targeting the military advantage if there is likelihood to the collateral damage or causing long-term damage. In the present case, it is very likely for the Roxana, if they are launching their nuclear missile, to rise in the collateral damage, and the effect of these nuclear missiles can be long-lasting, either to the civilians or to the environment itself. Moving to the second reasons on how we are claim that it is unlawful under the international humanitarian law, because the attack using hypersonic nuclear missile is indiscriminate attack, which can be resulted to unnecessary suffering. Under customary international humanitarian law, the usage of weapons that are naturally indiscriminate is prohibited. Indiscriminate weapon could refer to those weapons which cannot be redirected at military objective or whose effect cannot be limited as required by international humanitarian law. Furthermore, this nuclear missile can cause horrible effect, massive destructions, and huge losses to the civilians. Thus, the launch of a hypersonic nuclear missile leads to unnecessary suffering. However, this is something contrary within the international humanitarian law, which is stated that the use of means and method of warfare which are of a nature to cause superfluous injury or unnecessary suffering is prohibited. Third reason, the hypersonic nuclear missiles is a weapon massive destructive, which contradicts with the principle of distinctions. According to the Article 51, Paragraph 4 of the Additional Protocol 1 of the Geneva Convention, there are several prerequisites in determining its weapon as the indiscriminate attack. First, inability to separate military objective and civilian object. Second, the military advantage is excessive. Then, in the present case, the very natural behavior of this nuclear missile cannot be redirected to the certain object. Thus, it violates the principle of distinctions, which is unlawful under in this international humanitarian law. Your Excellency, we have to take notice. Even though Roxana's nuclear missile used expectedly to target against military objective, but the nuclear missile in very nature means that after being launched, their effect escape from the control of the launcher, or we can say that it is uncontrollable and may strike both combatants and civilians and create risk of excessive civilian causalities. This would put the civilian in a dangerous situations. That's the reason why it is prohibited under the international humanitarian law. Moving to the third
Agent,
sub-argumentations.
the
Why?
argument that you just
Yes.
gave, in terms of the effect that the attacks would have had on the civilians, do you think that can be distinguished as collateral damage in international law?
Yes, Your Excellency, it can be constituted as a collateral damage.
How so?
Because the effect existing to the civilians is this. I'm so sorry. I think that it is not a collateral damage because the way they are, the process of launching itself can involving their intelligence. So there are process of analysis on how they are avoiding to harming the civilian itself. However, by using their hypersonic nuclear missile, meaning that they are consented and they are due aware that the effect of these nuclear missiles can be excessively affecting to the civilian itself. While we do the fact that the octagon exists in the heart of the city or the nerve city of our country.
Okay, proceed.
Thank you so much. Moving to a third sub-argumentations. Roxana violate the human rights law. There are two reasons for this. The launch of hypersonic nuclear missiles by Roxana violated the highest attainability standard of living under ICESCR. The use of nuclear weapons would inflict such damage to the natural environment as a violate to the right of people to live in a healthful and ecological balanced environment. In the present case, the launch of Roxana's nuclear missiles within the idea of right and highest we, in the present case, the launch of Roxana's nuclear missile contradict with the idea of right and highest attainable of living and right to enjoy and utilize natural resources. Lastly, the attack who address the environment suffer is prohibited under the international humanitarian law. The second reason, addressing the octagon by the hypersonic nuclear missile proves the adequate infringement of the right to live. Under ICCPR, it's clearly declared that each human being has their inherent right to live. Considering the massive damage and undistinguished attack
Agent, excuse me, you have
yes,
arguments based on the ICESCR and ICCPR. Are
yeah,
these the parties of this case ratified to those conventions?
yes, both parties and this dispute are ratifying um, this ICCPR itself. It
Right,
is
and
access
where
on the
is
mood
that
problem.
stated in the? Okay, all right. Which paragraph is
Um,
that?
may I have a time to conclude my argument?
Sure, sure.
Okay, there is under paragraph 45 on the Moot problem, it stated that the party also ratifying the International Covenant on Civil and Political Right. Paragraph 45 on the Moot problem.
So that is civil and political right. Is it also ratified to the economic, cultural, and social rights one, ICASCR?
Oh, I thought you are asking for the second one. But why we are still putting ICE as CR on our first layer in these argumentations, because we say that these principles are something that is being common legal principle that is practices by the country itself, even if this party are not ratifying these issues, but they are exposed into this principle and the common sense on how people have a right to attain standard of living.
Okay. If that is the case, then are you suggesting that this could be considered as rules of customary international law, or are you saying that these are just general principles of international law, and it's a very, I mean, are you making a very generic argument, or are you making it based on customary international law?
It's stated it can be constituted as a customary international law.
Why is that? Do you have an
Because
authority?
if I may refer you into the ICG advisory opinions on uh, threat or nuclear weapons, paragraph 29, and also on the it is stated that a state must every state have the obligations to provide a proper standard of living, and it is also addressed, their advisory opinion addressed to this convention.
Yes. But does that judgment also provide that the rules of ICESCR would be assumed as customary international law?
Yes, because it is advisory opinions, or as the applicants, we believe that can be constituted as a part of opinio juris.
Okay, so advisory opinion based on the rules provided in the ICJ statute, the advisory opinions are not binding on the parties themselves. Then is it binding on us, or does it have any judicial precedence in this court?
Um, Your Excellency, indeed, there is no binding power in regard to this, but as the applicants, we respectfully providing this as the concrete reasoning on how there is like a common sense and of the international that we should provide the proper standard of living to the civilian.
So are you aware of the sources of international law provided in Article 38 of the ICJ statute?
Can you repeat your question,
Are
please?
you
Your
aware
Excellency.
of the sources of international law provided in Article 38(1) of the statute of this court?
Um, I do apologize. I cannot give you a proper answer for your questions.
Okay, proceed. Thank you.
Thank you so much. Um, Under that reason, it has proved that the dressing octagon is unlawful under international humanitarian law. Moving on to the second argumentations, Roxana entitled by reparations measures for the injury occurred. I saw that my time is almost elapsed, but if Your Excellency can give me 1 minute to conclude my argumentations, I'm more than
Sure,
happy for that.
please.
Thank you so much. Why Roxana entitled for a reparation measures under two reasons. First, Roxana act is act, act Roxana attack is constituted as an international wrongful act under two thresholds. Their actions attributable under the state. Second, there is a breach of international obligations, which is the obligation to maintain security and peace. Right. Second, it is also unlawful under international humanitarian law. It is unlawful also under the charter. It is unlawful under the fundamental human right, and it is with the principle of right to live and highest attainable standard of living. Thus, it is also thus Azura is can be stipulated as injury state for this because we are have more harm compared to the other parties. And the last reason, Roxana has responsibility to pay reparations for the Azura itself for the all actions conducted by them to our country. To conclude our submissions here, we submit that Roxana violated international law by targeting Octagon with its supersonic missile and must pay reparations to the Republic of Azura for the damage suffered. Thank you. Madam President, Your Excellency, may it please the court.
I think we can proceed with the
Excuse
responses.
me. Okay, thank you, Your Excellency. Good afternoon, Madam President, Your Excellency. May it please the court. My name is Afiq Ahmad Hanif, and I have the honor to appear on behalf of the Republic of Roxana, the respondent in today's proceeding. I will speak for 16 minutes, and my co-agent, Ms. Johanna, will speak for 17 minutes. And with your permission, we reserve 2 minutes for sur rebuttal. Your Excellency, over the course of the next 16 minutes, I will be submitting that Republic of Azura violated international law by launching military attacks against United Provinces of Roxana and must pay reparations for the damage suffered. And my co-agent will submitting regarding our second submission that United Provinces of Roxana acted in accordance with international law in targeting Octagon with its hypersonic nuclear missile and need not pay reparations to the Republic of Azura for the damage suffered. If this court doesn't have a preliminary inquiry, may I proceed to my first submission? Thank you, Your Excellency. The military attack conducted by Republic of Azura occurred in Roxana territory on 15 October 2022 and constituted a breach of international law and principle of international law.
Agent, excuse me. You state that this
Yes,
was a
Your Honor.
military attack, but the applicants say that this was not a military attack or it does not qualify as military objectives. What is your argument to defend that point? Whether how do you define that this was a military attack? What are the elements?
Your Excellency, if I may to explain more on my argument later on, entering our first submission, we submit that firstly, Azura military attack violates international law by launching an attack towards Roxana. And secondly, Azura is obligated to compensate Roxana for the impacts. Your Excellency, in the first issue, we submit that Azura committed an act of aggression. Secondly, in any event, international law does not recognize preemptive self-defense. And lastly, the possession of nuclear weapons is not prohibited under international law. Entering to our first argument that Azura committed an act of aggression. The attack conducted by Azura is an act of aggression, whereas under customary international law, the threshold for this action has stated explicitly. To fulfill the requirement of an act of aggression, Azura has breached the principle of non-use of force and violates the sovereignty of another territory. Moving to our first sub-argument that Azura has breached the principle of non-use of force. The attack launched by Azura on Roxana's territory is a clear violation of Article 2, Paragraph 4 of the United Nations Charter regarding the prohibition of the use of force against another state territory. Moreover, the prohibition of non-use of force is also recognized as a peremptory norm and customary international law. The Republic of Azura launched a conventional attack against United Provinces of Roxana, utilizing its land, air, and naval forces in a coordinated assault. Thus, the attack was a breach of Roxana's territorial integrity and the principle of non-use of force. Our second argument, Azura's military attack violates the sovereignty of Roxana. The concept of sovereignty comprises the possession of supreme authority of a state, including the power of regulating its international affairs without foreign dictation. The decision of ICJ on the Corfu Channel case emphasizes that it is fundamental for states to respect territorial sovereignty in the matter of international relations. The statement made by United Provinces of Roxana's Ministry of Foreign Affairs that the attack was a blatant violation of international law and their sovereignty. Based on the Article 2, Paragraph 4 of the Charter, it is clear that the breach of a state's territorial integrity is a violation of sovereignty. Our second argument, in any event, international law does not recognize preemptive self-defense. Under international law, preemptive self-defense is not recognized since Article 51 of the United Nations Charter only recognizes individual or collective self-defense. But in the present case, Republic of Azura launched the attack under the doctrine of preemptive self-defense, which has never been explicitly regulated in the United Nations Charter. Furthermore, Republic of Azura didn't fulfill the requirements of self-defense, which is the military attack is not proportionate and the attack is not necessary. Here we submit our sub-argument that the military attack is not proportionate. The attack launched by Republic of Azura is not proportionate since there was a loss of civilian life and the well-being of United Provinces of Roxana's citizens. It is stated in Article 51 Geneva Convention Additional Protocol 1 that civilians must be kept away from the danger of military operations. Thus, the attack violated international law and didn't fulfill the proportionate requirement. To the second threshold for our sub-argument, the attack is not necessary since there is no armed attack prior. In the Nicaragua case, the requirement of necessary is well established that only if an armed attack occurs is it necessary to respond to it. Hence, the military attack launched by Republic of Azura is unnecessary. And lastly, on our argument in this issue, the possession of nuclear weapons is not prohibited under international law. The hypersonic nuclear missile under the possession of United Provinces of Roxana is not a violation of international law since the Lotus Principle allows for states to exercise their jurisdiction and their sovereignty if there is no explicit international legal framework that prohibits to do so. The legality of nuclear weapons is also stated in the advisory opinion of legality of the threat or use of nuclear weapons, where there is no universal prohibition of the threat or use of nuclear weapons as such. Thus, absent such prohibitory rule, states have the right to use nuclear weapons. Move to our second major argument. Azura is obligated to compensate Roxana for the impacts. It was described that the military attack carried out by Azura, resulting in widespread devastation and loss of life throughout the United Provinces of Roxana, is a breach of international law. Regarding this problem, the obligation of reparation is formulated in Article 31 of RCWA as the immediate corollary of a state's responsibility. The responsible state the obligation to make full reparation is the general obligation of the responsible state consequent upon the commission of an international wrongful act. Under this reason, Roxana respectfully asked the court to declare that Azura is entitled to obtain compensation for all the damages caused by Azura. Unless Your Excellency have future question, this concluded our argument. May it please the court. Thank you.
My question is still not answered, which was, why do you suggest or why do you submit that this was a military attack while the applicants say that the entire situation lacked the elements of military objective, which means that it wouldn't be decided or defined as a military attack, maybe something else, but not military. So in order for you to say that this was a military attack, You have to define to me or the court that yes, this was military attack, and these are the elements of military attack, and it was present in this case. Do you have any such elements or definition of military attack in the international law which you can refer to?
Your Excellency, may I have a second to gather my thoughts regarding
Yes,
this
please.
question? Your Excellency, if I may refer you to the article, to the paragraph 24 of the facts, it is stated that Azura deployed its ground forces to this key strategic location and established a buffer zone along the border between the two countries. Therefore, we constitute that this wave of strike is a military attack.
Thank you very much. Please, the second respondent may proceed.
Good afternoon, Madam President, Your Excellencies, may it please the Court. My name is Johanna. I am the co-agent appearing on behalf of United Provinces of Roxana. As introduced by the first agent, I will be dealing with the second submissions in the next 17 minutes. I have the honor to address respondents' final submissions concerning United Provinces of Roxana acted in accordance with international law in targeting Octagon with its hypersonic nuclear missile and did not need to pay reparation to the Republic of Azura for the damage suffered. If there are no preliminary inquiry, we would like to continue to our submissions. Thank you. On 29 October 2022, Roxana launched a military attack against Azura's military command and control center. Roxana exercised the right of self-defense under Article 51 of UN Charter, which gives an inherent right of a state in response when an armed attack occurs. In light of these matters, there are three questions that need to be exercised by this court. Firstly, Roxana's attack in accordance with international law. Secondly, the attacks are in accordance with IHL. And lastly, in any event, Roxana did not have any obligation to pay the reparation. Your Excellencies, moving to our first major arguments, we submit that Roxana's attack in accordance with international law because first, the attack in Octagon constitutes a self-defense. In Nicaragua, to consider an attack as a self-defense, it must fulfill that there is an armed attack occurred, necessity, proportionality, and in any event, the attack must be directed against legitimate military targets. Turning to our first threshold, here we submit that there is an armed attack occurred. Article 51 of the UN Charter requires if there is an armed attack occur. In Congo, the court did not justify Uganda's self-defense due to there is no armed attack occurs. The court also refers to the Article 31 of Vienna Convention on the Law of Treaties that treaty must be interpreted with the ordinary meaning. Similarly, since the Charter explicitly stated that there must be an armed attack occurred, Roxana's attacks against Azura is justifiable due to in response of Azura's military attack in Roxana's territory. Thus, Roxana's attack was held in response to Azura's attack. Secondly, the attack has fulfilled the necessity. In Nicaragua, to determine the element of necessity, the court refers to the military attack that is needed to respond to Azura's attack. In the present case, Roxana has even twice attacking Octagon. Through that, Roxana needs to respond to the attack since it threatens Roxana's sovereignty. Thus, Roxana has fulfilled the necessity. Thirdly, targeting the Octagon has fulfilled the proportionality. In considering the principle of proportionality, the court in Nicaragua military and paramilitary adopted criteria nature of the target of the use of force in the term of self-defense, which refers to a legitimate target, and it must be shown that it had a military purpose. Here, Roxana act of self-defense was proportionate because it's only directed towards Octagon. Hence, the attack in Octagon has fulfilled.
This kind of attacks that are taken between states, even if we consider the fact that this was targeted for a certain area of a country or a city, a certain specific location, do you really think that it is possible humanely or practically that it would only attack the target and it would simply not touch the surrounding areas? Is it possible at all?
Madam President, we do aware that our attack would be have an impact to the civilians, but our attacks is necessary to protect our sovereignty because that was our last resort. And then,
okay, if you consider that to be your last resort, then you should also be aware that this kind of damages that are done, that I asked the applicants as well, do you consider that to be the collateral damage of your attack?
we do aware that our attack would be cause a collateral damage, but Madam President.
I'm very sorry to interrupt you, but if you say that this was a collateral damage, is collateral damage accepted or recognized in international law, or if yes, then where?
Mr. President, may I please have a minute to conclude my answer?
Sure.
Thank you. Mr. President, our nuclear missile attacks is our last resort because Republic of Azura was destroy our military bases. That's why we are using our last resort. That was our hypersonic nuclear missile. Moving to our second major argument, here we submit that Roxana's attacks are in accordance with IHL. In the armed conflict, the parties must act in accordance with the international humanitarian law. Here, since Azuras has attacked Roxana's territory, thus the IHL is applied in response to Azuras' military attack. Roxana has acted in accordance with IHL since the attack has fulfilled the IHL principles, and in any event, the launch of nuclear missile is lawful. Mr. President, turning to our first sub-argument, here we submit that the attacks are in accordance with the principle under IHL. There are three basic principles under IHL that must be fulfilled in attacking the target, which are: the target constitutes as military objectives, and Secondly, apply the principle of distinction. And lastly, the attack was consistent with the principle of humanity. Turning to the first threshold, we submit that Octagon is a military objectives. Any civilian object used for military objectives loses its civilian character and qualifies as a military objective. In Article 52, Paragraph 2 of Additional Protocol 1 provides that attack shall be limited strictly to military objective. The object targeted should be directly used by the enemy force, and its destruction will give definite military advantage. Here, Octagon was used by Azura for their military efforts, such as overseeing and directing the entire armed forces. Therefore, Octagon is a military objective. Secondly, the launching of nuclear missile was applied the principle of distinction. To determine that the attack is consistent with the principle of distinction in nuclear weapon advisory opinion, the court refers that the object of attack must not directed against civilian. In Nicaragua, United States of America conducted a military attack through military troops and directly attacking the civilian by shooting. Here, Roxana's attack did not directed against civilian and only directed against Octagon. Thus, the launching of nuclear missile was applied the principle of distinction. Lastly, the attacks were consistent with the principle of humanity. To fulfill the element of to justify the attack, it has to be in accordance with the principle of humanity. To consider that it has fulfilled the element of humanity, the court in Persecutor versus Parlik stated that the principle of humanity must to be balanced with the principle of military necessity. The principle of military necessity permits the use of force in order to achieve the military advantage. In the present case, Roxana has a specific military advantage, which by targeting the Octagon, it would weaken Azura's military attack to Roxana. Thus, the attacks were consistent with the principle of humanity. Moving to our second
I'm not aware of the principle of humanity. Can you refer to me which subject of international law deals with the principle of humanity? Or is it provided by any treaty, any law, or where can I find it? Because I personally have not heard of it, so I would like to learn.
Madam President, may I have a minute to conclude my answer? I'm sorry, Madam President, I cannot provide you with the answer.
Okay, that's it.
Thank you. Secondly, in any event, the launch of nuclear missile is lawful. There is no prohibition in launching nuclear missile. In nuclear weapons advisory opinion, the court stated that there is no prohibition of using the nuclear missile. However, the attack must be fulfilled the proportionality in attacks, and in any event, the casualty is justified as a collateral damage. Turning to our first threshold, here we submit that the attack has fulfilled the element of proportionality in the attacks. Proportionality of an attack requires the balance between the destructive effect and undesirable damage. Under IHL, states are prohibited to launch an attack if the damage anticipated to the civilian would be excessive compared to the military advantage pursued. Here, Roxana has announced that the launch of the nuclear missile. This is proved when Azura activated the missile defense, concluding that the damage of the attack will be proportional. Therefore, the attacks were proportional. Turning to our second threshold, here we submit that the civilian causality is justified as a collateral damage. In international law, if the attack occurs by the knowledge that such attack will cause incidental loss of life or injury is forbidden, but launch an attack that had no intention of causing harm to the citizen may be permissible.
Okay, so that is the case that you did not, I mean, in order for that to just, I mean, be justified as collateral damage, it needs to be in a way that I didn't have the intention to kill these people, then these people have been killed. But at the same time, you are aware that if you target some location in that city, as we spoke about it before, if we target that particular area and we maybe launch an attack, that we know that this is going to affect or harm civilians, innocent people that have no connection with this issue between you and your other party. But then how is it that you justify that it was a collateral damage, even if the fact that it didn't have intention, but you had the knowledge that it was going to take place, it was going to harm these people, then how is it collateral damage?
Madam President, we do aware that it would it will notification. That was our last resort, Madam President.
Okay, proceed.
Moving to our last, moving to our last major arguments, we submit that in any event, Roxana is not obligated to pay any compensation to Azura because Roxana attack was not internationally wrongful act. A state is under the obligation to make compensation for the injury caused by an international wrongful act. Here, Roxana's attack was not an internationally wrongful act. Therefore, Roxana is not obligated to pay the compensation. Um, in any event, if this court finds that there is a wrongfulness, here we submit that Roxana did not have any obligation to pay the reparation since under Article 21 of the RCWA, the wrongfulness of an act of state is precluded if the act constitutes as a lawful measure of self-defense under the Charter. Mr. President, Madam President, to conclude our submission, here we submit that United Provinces of Roxana acted in accordance with international law in targeting the Octagon with its hypersonic nuclear missile and did not have any obligation to pay reparation to Republic of Azura for the damage suffered. Thank you, and may it please the court.
Thank you very much. I think we can proceed to rebuttal.
Am I audible, Your Excellency?
You're audible.
Okay, thank you. I'm going to start in 3, 2, 1, go. Your Excellency, as what we already proposed at very first place, that we are going to reserve 2 minutes for rebuttal. My name is Nazal Amin Firdaus, acting as the second agent applied for doing in this proceeding. Your Excellency, if you notice under this proceeding, both parties claim that the actions is the last resort for both of us. But let's see what is the distinguish between our last resort and their last resort. How to considering which last resort is justifiable. It started in a process of diplomacy. It proven on how their side as the Roxana have no any intentions to open the transparency of the discourse itself. Even though through the annex they would like to say that oh, they are open for the discussions and so on and so forth. But in fact, in practice, as you can see in the Moot problems, they are trying to dismissing, they are trying to gaslighting the opponent party, or this and shallow the discourse exists and social media itself. It shows that there is no good faith and for this discourse itself. Thus, we as the applicants see that it is real imminent threat for us because they didn't show their real intentions by developing these nuclear missiles itself. So that's justifiable for us to using our last resort to do so. It difference with their last resort, it is not proportionate, it is not unlawful in distinction principle because their effect is not able to equal with the earlier strike that we are conducted for. So it is unproportionate. It is not direct to the military objective itself. It is causing collateral damage, and they are aware about the effect of this. Thank you. May it please the court.
Madam President, representing the respondent state for this short rebuttal session, we address that it is true that it is our last resort since the attack of Azura on our territory made our country in the brink of collapse with much of its infrastructure destroyed and its armed forces is in disarray. And since we have no other resort to launch our to exercise our self-defense, therefore it is very necessary for us to take this step towards the Republic of Azura since we have no other option. And then regarding about the transparency that the applicant state submitted, here we submit that under international law, we can exercise our jurisdiction in our territory without any foreign dictation. Therefore, we don't see any reason and what is the capacity for applicant state to exercise that attack on us, since we did our best to resolve about the threat regarding our hypersonic nuclear missile, yet it is the applicant state who took the first action to attack our territory. That should conclude our short rebuttal session. Thank you so much, Your Excellency. May it please the court.
Okay. Your Excellencies, that concludes the round. So we will now adjourn to the deliberation room for further proceedings. The participants will move to the breakout room. Please wait a moment.
Thank you, respondent. Thank you, Your Excellency.
Thank you so much.
Ms. Tarzi, can I ask, are you aware of the team codes?
Let me just confirm with you. I have
Okay.
taken note that the applicant was 1004 and the respondent was 1003, right?
Yes, that's correct.
And I have the names for the applicants, but I would need your assistance to get the names of the respondents.
If I may have a moment, please, let me just assign them to the breakout room. Uh,
Hello?
All right. Okay. Done. Sorry, Ms. Nardi, how can I assist you?
Yes.
Yes, you were correct. The team codes are correct.
Yes. I would need your assistance to get the names of the respondent team.
The respondent team.
Would you please send me the names on WhatsApp maybe? That would be better because the spellings.
All right, sure. I will send it to you now.
Okay. I'm just finishing up the score sheet and send it to you. All right.
All right. Angel, can I confirm with you? Respondent 1 was Afiq Ahmad. Respondent 2 was Johanna. Is that correct?
Yes.
Master, I would also need to know the room
Yes.
number.
All right. Yes, on my correct, right? It is room 2.
Room 2. Preliminary round 2, room 2, right?
Yes, that's correct.
Yes.
Thank you.
Yes, Mr. Ibra.
Hello.
Hello, yes, we can hear you.
Yes. Am I audible now?
Yes, you are.
Uh, can you can you please confirm the first applicant name?
Angel? Sorry, Angel, can you confirm the applicant names? I can't hear you. We can't hear you.
Hello.
Yes.
The first applicant is Muhammad Ahsan Adityatma Amir, while the second applicant is Nazal Amin Firdaus.
Number 1 was Muhammad. Number 2 was Nazal.
Yes.
All right.
Please WhatsApp
The respondent?
both applicant and respondent.
Sorry, you are breaking a little. Can you repeat your question?
I'm asking for the names. If you could kindly send it on WhatsApp.
Oh,
Both
sure. All right.
The first respondent is Afiq Ahmad Hanif.
Give me a moment, Angel.
The
A1 was Afik. Sorry, applicant one.
Ahmad Hanif. Applicant. Is
Applicant
it the
one.
applicant or the respondent?
Can you repeat the
The-
applicant?
The applicant is Muhammad Ahsan.
Okay, applicant two.
Nazal Amin Firdaus.
Nazal. I've sent it to you, Mr. Ibrahim. Please do let us know once you have submitted the scores. Thank you.
Umasri, I sent my score sheet.
All right, thank you so much. We have received the score sheets. Thank you, Mr. Razin.
I have sent my score sheet as well. If you could kindly confirm.
Sorry, if I may have a moment, I will confirm it for you. Right, yes, we have received your score sheet. Thank you very much. So we can
Thank you.
move on to the feedback session. I will add the participants back to this room. All right, so judges, you may begin the feedback session. Thank you.
I think I cannot see the participants.
Participants, can you please turn on your cameras? Thank you.
I think we can start if all the participants are here. First of all, again, congratulations on completion of this session. It was fantastic. I personally enjoyed a lot. I would just give a little bit of feedback individually that I do in every session. In terms of applicant one, I had a session with you today earlier in the morning, and I would say that from that to now, you have improved a lot, like a whole lot, which is very appreciable. And you've done, I mean, a lot of research. You've been able to showcase the research that you've been doing for a while, and I'm sure that you did know these things in the first session, but then I don't know why, probably because of the this wholesome situation. It can be overwhelming sometimes, but the way you presented it this time, it was fantastic. I really commend that. In terms of applicant two did well in the previous round and this round as well. He's been doing very well. One feedback for applicant two is to be I need you to be more composed. When I say more composed, what I mean is that you stay within your space and you speak to me. You do not move your hands too much, because when you this is an online session, I understand, but when you go to the podium, you basically have the space as much as you have in the podium. So you do not move your hands up and tell the judges that this is what happened, that is what happened, 2 3. You don't do that. When in the moot court competition, or even if you go to the real courtroom, you have to be very composed and very calm in terms of your physical body language, okay? Because that shows that you're very firm and confident with your language and your arguments. Your basis is very strong, and whatever you say to the judge, because everything about your body language will be shown in your face. Your expressions will decide whether you are right or wrong. Your smiling, your confidence, the way you get angry when something comes that the respondent did very wrong to your country, the expressions will speak for you, not the body language. Other than that, research and the way you answer questions, it's very commendable. I appreciate that one. I think one question that I asked you regarding, look, there are very basic situations in international law that we must know when we do moot courts. I don't know what is your level of studies, if you're in third year, fourth year, or first year. I don't know that. I would just suggest that you must study the basic principles, like Article 2.4 of the UN Charter, the Article 38 of the Statute of the International Court of Justice. Because every time I ask you for authority, that you're referring to this resolution, advisory opinion, opinion juris, dissenting opinion, whatever, a book, a principle, anything that you're referring to, if I ask you for authority, what I want you to tell me is that, Your Excellency, this is not binding, but this is acceptable to this court under Article 38(1) A, B, C, D. It is a customary, it is opinion juris, it is opinion of the highly qualified publicist of international law, it is general principle of international law, whatever that is, whatever the source is of international law, that should be within the ambit of Article 38(1)D and Article 38(1), and you have to be able to make me understand that it is within that ambit. I'm not speaking against that, okay? Other than that, I think applicant, very well done. In terms of respondent, very good job. You guys, it shows that you guys have worked very hard. First of all, respondent one, you did well. You have a very good composition. You have a very good starting. But whenever the judge asks you, let's say if before you even begin your submission, the judge will ask you something. Can you say that? I understand that in any part of your submission, you have that answer in your submission. But if the judge asks you, you have to address that maybe in one line. So you say that, Your Excellency, this is in one line, you say that this is our submission. However, we will elaborate on this further on in our next submission, in our further submission. When you say that, judge feels good that yes, he knows what he's saying. Maybe I shouldn't have asked this early, or maybe I should wait for him to finish that. Okay. Other than that, you did well. I think you remained very composed, calm, and you seemed pretty confident. In terms of the second respondent, I think you have a very good, I wrote in the feedback sheet that you have a very good poise, that the way you speak, the way you began your submission, the structure of your submission, it was very well done. Other than that, the research and law, it was quite good. I'm sure that you, all of you, understand that you need extensive research on your laws and how you connect the laws, and you must be able to, I'm saying that for every team, you must be able to distinguish between IHL, international humanitarian law, international human rights law, international law, public international law, these things, because these might seem similar, but you must be able to distinguish between that. And one problem regarding definition, I've been noticing since the morning. If you say something, you must know the definition. You must know the definition of collateral damage. You must know the definition of military objective. You must know the definition of use of force. Definitions are very important. In every session, judges will ask you definitions, because that is what the only thing that matters. If your submission doesn't fall within the ambit of the definition, you just win the case. Okay. I would suggest that. And one last feedback for every team, which is, when the judges ask you something and you need some time to recollect your thoughts, you say that, Your Excellency, may I please get some time to get a moment to conclude my submission. I think you guys say that, or maybe you guys say that to think about my. But then you have to think, not act. When you ask me for time and I give you time, then you're acting, maybe talking to your teammate. You cannot do that. What you have to do is, when I give you the time, you open your own sheets, like whatever you have in front of you, the files, wherever you've written that answer, you open that and then you tell me, and you have to be very brief about that. So if you take one moment for me, which means you're taking 30 seconds, maximum of 30 seconds from me, but you cannot keep me waiting for the answer, because you're keeping the entire courtroom and the other party, and your time is also I mean, it's also killing your time. So I think these all will be my feedback. I really enjoyed the sessions. Of course, thanks to the bailiff and technical assistant and the organizers. It has been amazing to be a part of this session. Thank you so much.
Okay. I would like to give very generalized feedback to all of you. First of all, accept my apologies for a very bad internet. I tried my level best to cope up with it, but unfortunately, due to certain situation, I was not able to, ensure my good connectivity. One thing, because I judge you guys before, and what the reason behind my aggressiveness was that I was checking your composure, that how can you handle my questions and how can you handle that pressure, whether you guys can handle that pressure or not, and whether you guys can do answer with that pressure or not. So that is the main objective behind being a bit aggressive while I was asking questions. Secondly, I would like to advise you that whatever case you are citing, please do contextualize it. Like, for instance, if that was a self-defense, that first you need to, establish before the court that what is preemptive self-defense. Like, the facts were about preemptive self-defense. So first you need to establish that, and then extend your, whatever the principle has been laid down in any case law, you are supposed to extend that out to your own facts and and your own situation. uh, Again, you were composed, you all were composed, just for the applicant, nasal amine. Yes, you need to work more on your composure and the way you handle questions. And please do not give clear-cut, straightforward answers. If you do not, because what happens is that you were shaking your own arguments at that point of time. Like, your overall arguments were very good, but when I used to pose questions, sometimes you would be very straight to it, like, and you would be sometimes you would succumb to the pressure. So don't do that. Just play with the fact. Just play with the law. Because if your answer is wrong and then you are confident about it, that's what your personality and your argument uh, shakes to the core. So please do avoid that. And overall, it was a very good experience. So a very good luck to all of you.
Alright. So that is the end for the second preliminary round. So thank you so much to all the participants and honorable judges. So you may leave the room now.
Thank you. Thank you very much, judges, for coming in. Really appreciate it. Have a great day ahead.
Thank you very
Thank
much.
you, participants. Thank you so much for your understanding.
Thank you so much.
We will see you at the announcement.
Bye bye.
Okay, all right.
Not yet.
Hey, recording. Recording.
Good job. Good job.
Good job, everyone. Okay, so